SJC-13177, Freda Battle, personal representative of the estate of Charles R. Dunn, v. Barbara A. Howard.
Attorney Walsh.
Good morning, Attorney Daniel Walsh on behalf of Barbara Howard. May it please the court. We're before the court today asking the court to determine that the lower court erred in denying Barbara Howard's motion to dismiss. This case, of course, involves a petition for partition that was filed in September 2020. Ms. Howard and Mr. Dunn own the property in question as joint tenants. It's a property in Boston, a two-family home that they purchased in February of 1993. The court issued the warrant on December 11, 2020, followed by an amended warrant just correcting some typographical errors on December 16th, 2020. On January 30th, 2021, the commissioner accepted an offer to purchase the property. Mr. Dunn passed just about 2 weeks later on February 16, 2020. A few days later, on behalf of Ms. Howard, I filed a motion to stay the proceedings, followed by a motion.
So, counsel, I think we may be familiar with the procedural history here, so I'll just ask you a question. Why is not the issuance of the warrant the event that severed the four unities?
The issuance of the warrant is really a procedural matter. It just establishes, it gives direction to the commissioner. It doesn't change any of the ownership rights. I would look at section 10 of 241, and it says that the warrant is issued to the commissioner to make partition. So the partition occurs at some point in the future. So the issuance of the warrant itself really doesn't change any of the rights of the party. Excuse me. And again, looking at the four unities, if we go back to the basic property law, none of those unities are destroyed by the issuance of the warrant.
So then can I ask you a follow-up question, counsel?
Of course.
How do you explain section 26, which seems to say if the court receives notice that the death has occurred, then the share or portion formerly belonging to the decedent may be assigned or set off in the decedent's name to be held and disposed of as if the partition had been made prior to his death?
Thank you.
What does that language mean in the context of a joint tenancy?
Well, we have to break that section down just a bit, Justice Wendell. If we look at the very first part of the section, it says if a party named in the petition has died prior to the filing thereof. So if we look at just that section, if it was strictly interpreted to mean that at any point the descendants of a joint tenant could then file a petition for partition, it would radically change probate law. I mean, certainly the court can envision that the heirs of a joint tenant, perhaps second marriages or whatever, are dissatisfied when that parent perhaps passes away. They could completely circumvent property law by filing a petition for partition when that joint tenant had no intention at all to do so. So I have to admit, when I read section 26 the first time as well, I thought that was conclusive. But when one really kind of parses this out a little bit, it really doesn't make sense. And the statute has to be read in its entirety. So we can't just ignore this first section of the statute that says when someone has died prior to the filing thereof. That doesn't allow the heirs of that joint owner to then file a petition for partition, which would abrogate joint tenancy property law. That's how.
Does it really have to? I mean, it says that the heirs shall be entitled to the share of land set off to the decedent. And if he died before the partition, there is no share of land set off to him anymore.
But the statute does refer to somebody being able to file after death and prior to the filing thereof. So it's difficult.
But counsel, don't we have to factor into that this sale was not complete, that there was still a need, the P&S hadn't even been signed. So we're not that far along, right?
Absolutely, and I think that's critical. There's been no conveyance. That's the point at which the joint tenancy is severed, and section 17 says that.
I'm confused though. We got to give some meaning to 26. We can't just say it's stupid. So what is the meaning you give to it? Is it that it only applies to tenants in common? How do we make sense of it? So help us out here, because we can't just leave with it's a bad thing.
No, I thank you, just Kafka. And I think you're right on point. It would apply to tenants in common. I mean, with a tenancy in common, the heirs do have an interest in the property. I mean, that's
you wanted to read the words tenancy in common into section 2. We usually don't do that.
No, I understand. I'm not looking to read something into it. I'm just trying to give the court my interpretation. So again, otherwise, what would it would allow the heirs of a joint tenant to pursue a partition as with a strict reading of the statute. But considering as a tenancy in common, it would certainly allow those heirs to, after the death of that tenant in common, to file a petition for partition. That's a logical reading of the statute. Otherwise, we're reading into it rights to the heirs of a joint tenant that simply don't exist.
But could we read it in, say we read in what Justice Wendland's first question was, when the warrant issues, sort of the game changes a little bit. Could 26 be sort of a, once the process is started provision, you can do this, or once the process is far enough along that a warrant is issued, that then 26 makes some sense? I mean, I'd be honest, I don't follow this, so I'm asking for help. I'm not, this is not a rhetorical question.
No, I appreciate that. But you're saying you're not following section 26?
Well, I'm trying to give meaning to, I got to give meaning to 26. I can't say that it's a dumb statute. So one meaning I gave to it is it's designed for this kind of situation where the warrant is issued or this is far enough along that then it applies. Because I understand your point that we can't read that first sentence to just say, if somebody dies beforehand, but I'm trying to find some, looking at this as sort of a, when the process is started, section 26 kicks in, but I may be wrong, but that's you. I'm trying to make sense of it.
No, thank you. But once the process has started, still, chapter 241 is really a procedural guide. I'm suggesting, excuse me, I'm suggesting to the court that the legal rights of joint tenant or the legal aspects of joint tenancy do not change at any point during a partition until the land is actually conveyed. So there's statutory support for that as well. I'd refer the court to section 18 of 241. Starts the petition by division when confirmed and established by final decree under section 16, which doesn't apply to the case at hand, or the sale, if the partition is made by sale, shall be conclusive. So that's the point at which everything is conclusive. The interim decree is really a set of instructions. There's nothing that I found in either the statute or in case law that would change the nature of joint tenancy by the issuance of the decree. Here in section 18, we're reading that it's actually the sale that is the conclusive act, is the conveyance by the commissioner. So,
Counsel, what do you mean by issuance of the decree? That interim order that says this is a joint tenancy?
correct.
If that order had said this is now a tenancy in common, then that would have been conclusive, if not appealed and became final?
Well, that's very true. And that was determined in Cowden v. Cutting, 339 Mass 164, where the decree was actually incorrect. The decree determined it was a tenancy in common when in fact the deed says it was a joint tenancy. And that wasn't appealed, and that was a final holding.
Yeah, so if that same error had happened here and it hadn't been appealed, then the heirs would be able to step in.
I agree.
Okay, and that would give some meaning to section 26, sentence 2.
Yes, absolutely. The second sentence, it would, absolutely. Yes,
Thank you.
thank you. Excuse me. But again, the lower court,
Mr. Walsh, when the commissioner accepted an offer to purchase the property, did the unity of interest change because of the interest that the would-be purchasers would have?
no, excuse me, no, it really didn't, Justice Lowy. What happened, and just in any, like in any residential or even commercial transaction, but when a seller, here it was the commissioner who was the agent by law of the sellers, the owners, when a seller accepts an offer, the seller now has an equitable obligation to convey the property, and the buyer has the opportunity to enforce that through specific performance. It doesn't change the nature of the ownership. It doesn't give the buyer the right to possession. It's just, it's a contract and it confers rights upon each party, really.
And that's true, you're saying, even in this case where there are all sorts of bells and whistles that say that this is contingent upon approval of the court, open to a hearing, parties can object. You're saying this is the same as in the, I forget the name of the case. Yes.
Yes, thank you, Justice. I am. There's nothing that changes. In fact, you know, the conditions you just cited might put a buyer on notice, actually, right? That this is tied up in partition and that anything could happen. But the fundamental rights, the contract rights between the buyer and the seller could be enforced.
Even though there's all sorts of notice issues that this is contingent. That wasn't the case in the M case, was it? Were there these contingencies?
In what case? I'm sorry, Justice Wendell.
I don't know, you just mentioned the name. Is it McCarthy? Yeah.
Oh,
McCarthy.
in McCarthy, it's correct. That was pretty straightforward, that the seller got a better offer essentially and then tried to sell it to somebody subsequently. So there weren't all the bells and whistles that you just mentioned. No, not that I know of anyways.
Okay.
But in this case,
Can we go back to the statute, section 26 for a minute?
yes,
Reading the first sentence, if a party named in the petition has died prior to the filing thereof or dies during its pendency, does that include the petitioner or just somebody named in the petition by the petitioner?
I would suggest it would include either party, either the petitioner or the respondent. Right, it's not identified in that statute. So,
Okay.
I mean, that raises a question as well. Could 2 of 3 joint owners, I guess they would have no incentive to do that with a respondent, but as far as the petitioner, I don't think it leaves the opportunity for the heirs of a joint owner to file a petition.
Mhm.
So, I would look to the reasoning of the lower court in the decision to deny the motion to dismiss. And the lower court put a lot of weight on the fact that there was a purchase and sale agreement and thought it was essentially inequitable to sort of turn one's back on that agreement. But again, it's a contract right. The court used its equitable powers to make the decision, but the rights of the parties involved in that would still exist. Even if this case was dismissed, the commissioner only acted as the agent of the owners of the property. So the buyers would still have a right for specific performance against Ms. Howard as the seller of the property. What happens after that, whether there's an agreement or some other type of resolution, who knows? But the buyers would not be prejudiced. So for the court to exercise its equitable powers because of that, I think is a little unfair, where Ms. Howard was a joint owner for 27 years with the intention of receiving the entire
Do we
fortune.
know do we know, Mr. Walsh, that's the reason for the equity determination? Because certainly you're right. If Ms. Howard has the full tenancy, then the purchase and sale could be enforced against her. But this seems to be a combination of common law and statutory interpretation. And to the extent it's common law, isn't there a place for equity here by the land court judge?
I don't believe so. I believe really it's a question of law in its essence. It's really the law involving joint tenancy. Certainly, land court and probate court can exercise equitable powers in, say, the distribution or allocation of funds or division of property. But in its essence, this is a question of law. What does a joint tenancy mean? Joint tenancy means the survivor inherits the interest owned by the other joint tenants.
Okay, are there any other questions? We'll turn to Attorney McKenzie.
Thank you.
Thank you.
Thank you, Madam Chief. Fellow members of the court, my name is Denzel McKenzie, and with me this morning, my colleague, Colin Krieger, and also Ms. Freda Battle, the personal representative of the decedent, Charles Dunn, should be tuning in also. We are very pleased that the court has seen fit to intervene and to bring some clarity to this somewhat thorny area of property law, which is largely out of the view of many practitioners engaged in the property law practice.
Attorney McKenzie, can I stop you and just ask, why isn't Attorney Walsh right here? That since the transaction didn't go through, generally joint tenancy means that there's a right of survivorship in the person who had the joint tenancy now has all of it now that the joint tenant has passed.
I tell you why, Your Honor, if the court were to follow the path that Attorney Walsh has invited the court to go on, the court would be renouncing lots of property law. For example, it would simply overturn Tobin and McCarthy. Tobin and McCarthy say the deal is done. Once you've signed, you've accepted the offer, the deal is done. And what Attorney Walsh is inviting is that, notwithstanding Tobin and McCarthy, the buyers or the disappointed buyer should go ahead and sue. Go ahead and sue the surviving joint tenant. What that means, Your Honor, is just exactly what everyone runs away from, which is inviting additional traffic to the courts. It's inviting a certain amount of uncertainty to the business. The law runs best on certainty, not on uncertainty. This is not a case of going to the casino where you're going to spin the roulette table or going in the direction of uncertainty. This society works off certainty. And what my brother has invited and what he is suggesting is that, notwithstanding the fact that an offer has been made, notwithstanding the fact that an offer has been accepted, but there is this open-ended situation that can set in at any time, and that open-ended situation can serve to hurt everyone. I'd like to suggest, Your Honor, the statute that we're looking at goes all the way back in time, all the way back to the 1600s. The last update that we had was done in 1917, and prior to that update has remained in place since 1970. It has not been amended. It has been going on, and the entire society has been operating off this very stable and very predictable and somewhat elegant statute. Now, what my brother is suggesting is that the statute is intended solely for the benefit of the joint tenants. But here's the situation. The very first sentence of the statute says that if the plaintiff or the petitioner files naming a joint tenant who has died, the legislator said, too bad. The joint tenant has died and you did not find out what it is. And we're going to simply say that that joint tenant will share and will share equitably in the proceeds from the partition. Then it goes on in the second sentence that speaks.
Counsel, can I ask you a question about that?
Yes, ma'am.
Or ask you to clarify that. Are you saying that if I own property as a joint tenancy and I file and my joint tenant dies, then I can file a petitioned for partition and the heirs of my joint tenant now get something?
No, Your Honor, that is not what I'm saying. I'm saying the
Good, I'm
legislators say
I
that
didn't think so.
the legislator is saying that if you were careless enough not to note that your joint tenant has died and you come into court for a petition, we're going to treat it as though he or she is alive, and we're going to pass on his or her share to the heirs of the deceased's joint tenant. That's first sentence of the statute.
Yeah, that seems exactly what, yeah, that's what I was concerned you're saying. You're saying you can revive the interests of a dead joint tenant
It's
by
not
being
I wouldn't-
careless in filing a petition for partition?
Your Honor, I would not say revive, I would say preserve.
But upon death, normally, the right of survivorship kicks in, so that if I own property as a joint tenant, and my joint tenant, regardless of whether I know it or not, dies, I own it in full.
No, Your Honor, I'm saying that if you filed, the petitioner filed, naming a joint tenant who has died, and the death is discovered during the proceeding, the legislators say that for purposes of that proceeding, the deceased joint owner will take, and the third sentence says that in that instance, the court can decide whether the taking will be passed on to the personal representative of the decedent. And if there are no personal representatives, will wait. And if they wait and there's nothing comes, it goes through section 34, which is the abandoned property provisions that is written into General Laws, chapter 241. So the legislator was very thoughtful in the 1917 Act, which is the one we're working with, very thoughtful in addressing many of these concerns. Where the problem seems to have stepped in here is the situation that the courts have struggled with. The courts have been struggling for many years on the question of when does the joint tenancy in a partition proceeding gets broken. And we have seen over and over. In 1958, Minian against Minian said that it happens, but we don't know where, and we don't have to address it. In 1973, Wilder.
I'm sorry, Mr. McKenzie, didn't Minahan say that actually the filing of the petition doesn't impact the joint tenancy?
That is correct, Your Honor. The mere filing of the petition, nothing happens with the filing. And Wilder goes on to say that if you make a mistake, if the court makes a mistake in the characterization, then, and you do not correct the mistake in the form of an appeal from that mistake, then the petitioner is stuck with the mistake, changing a joint tenancy to a tenancy in common. By way of illustration, Your Honor, you filed the petition, a petitioner files a petition. The court then has an initial status conference. And at that status conference, the court, with the parties, the court will determine whether or not there's a dispute as to the character of ownership, such as where there might be a tenancy in the entirety that does not belong under the statute. In this case, the court had this very proceeding, and during the proceeding on September 4, the parties conceded that this was a joint tenancy because there's no dispute about it. There's no appeal taken from it. The second interlocutory order took place in December when the court issued a warrant, and that warrant is the specific and legal authorization appointing the commissioner to conduct the petition proceeding. No appeal was taken from that either. Both parties were satisfied going forward. Now, granted, Mr. Dunn was 94, I believe, and was expected that he would make it through to the end. It did not happen. But before that, in January, an offer was made. The offer was made, the offer was accepted. There were no dispute about the offer or anything of the sort. And both parties went about the business and trying to hammer out the details of the purchase and sale agreement. But I'd like to note, Your Honor, that Tobin and McCarthy downgraded the value of the purchase and sale agreement. So the P&S in this instance, or in all other instances, in order to preserve that, you've got to preserve it in the offer. That was not preserved in the offer. That says that there are some rights that will have to be enshrined in the purchase and sale agreement in order for the offer not to be binding.
Yeah.
The offer became binding.
Attorney McKenzie, can I ask you would it be possible or what would happen if the rule was that the petition, so your petitioner dies, your petitioner who wants to partition has died. If it were said that, well, it's all still a joint tenancy because nothing severed it, but the potential buyers can bring an action for specific performance against the joint tenants, would there be any legal ground they could use for that?
Yes, Your Honor, because there's a contract according to Tobin and McCarthy. There's a contract to be enforced, and that contract can be enforced. So the party who was injured by maybe the change of heart on the part of the surviving joint tenant, my brother has also conceded that what should happen is that the contract can and should be enforced by seeking enforcement action against the surviving joint tenants. Not only is that wasteful, Your Honor, but that also brings a level of uncertainty to the process that will spook everyone who gets involved in a petition proceedings. As it stands right now, we've got to caution all the parties in there about some of the bumps in the road that could pop up that would stand in the way of the proceeding coming to conclusion. To introduce and somewhat unwieldy one to say that one party can come in, change his mind, and if you want to buy this property, be prepared to spend another $20,000 or $30,000 to litigate that. That's usually not factored into the sale process. Now, granted, everyone plans, as Judge Long pointed out in the case of Z against Z, that there's a great deal of expenses involved, and he noted that in footnote number 6. All the expenses are involved in partitioning a property. And he did find, however, that in that instance where you had a three-party joint tenancy, that when one fell out, all that happens is that there is a second round at which there are only two parties. There is successorship that took place within the partition process. Now that's an excellent decision, except for one thing. Judge Long did not spend any time with Section 26. And it's a nice, short, elegant, and understandable opinion, but he did not address Section 26. Section 26 is not the demon that everyone tried to make it out to be. Section 26 is well thought out and well thought about by the legislature. It has been on the books and has been going continuously without much hitches since 1917. Now, granted, we've had a series of cases that have raised the question as to when does the joint tenancy gets disrupted, and that's what brings us here. We believe that Judge Foster was very careful, very thoughtful, and very intelligently went about in saying that because of the external laws involving property and the sale of properties, then this ball must stop rolling down the hill. And it happens when the commissioner has been appointed and the commissioner has accepted an offer, and all that remains were some minor details in tying things together. And if death took place, the legislator contemplated death. None of us can say for sure certain we'll be here today or tomorrow, but the legislature did speak specifically about possibilities of death. And it did so in the very first sentence of Section 26, and goes on to say more about it in the second sentence, and finally in the third sentence. We believe the statute is a rather wholesome, intelligent, and a very well thought out statute. And in fact, the legislature has not seen fit to interfere with it since 1917. And anyone at the bar or this court felt uncomfortable about it, normally this court would send a signal to the legislature, say this is a problem that you need to correct and address. That has not happened. And the
So
bar
the
has not gone
point at
very long.
which the right of survivorship ended is when the commissioner entered into or accepted the offer to purchase. That's your position.
My position is, that's correct, Your Honor. My position is that the land court was correct and the land court should be upheld because it was well thought out and very intelligent and very predictable. And that is what we rely on in the law.